Good afternoon, and welcome to Preparing for Your Community Health Choices Appeal, Part 2, the second webinar in a two-part series presented by PHLP attorneys David Gates and Amy Lowenstein. I'm Kayla McNally, the Project Administrator at the Pennsylvania Health Law Project, and I'd like to quickly go over a few items so you know how to participate in today's event. You will have the opportunity to submit questions to today's presenter by typing them into the Q&A pane of the control panel. You may send in your questions at any time during the webinar. We will collect them and address them at the end. This webinar is being recorded and the slides will be sent out after the webinar. If you have technical difficulties at any point, please hang up and dial back into the webinar. If the problem persists, you can email me at event, E-V-E-N-T, @phlp.org. And now I'll turn it over to Amy.
Thank you, Kayla. My name is Amy Lowenstein, and I am joined by David Gates. We are going to talk to you about appealing service changes and denials in community health choices today. So the focus of this webinar is asking a managed care organization in the Community Health Choices program to change a decision it's made to deny or change a service that somebody's been receiving. In other words, it's about appealing a decision. This is an overview so that you or someone you work with will know how to appeal a decision when you're unhappy with it. And I want to emphasize, though, that the Pennsylvania Health Law Project is here to answer questions, give advice, and assist people on an ongoing basis when they face challenges accessing or keeping services in the Community Health Choice program. Let me start by just giving a brief overview about the Pennsylvania Health Law Project. We are a statewide nonprofit legal organization dedicated to ensuring access to public health coverage and services. In support of that mission, we operate a helpline for clients and advocates. We provide free advice and legal representation, community education, trainings, and webinars like this one, as well as self-help materials. We publish a monthly email newsletter with updates on things that affect Pennsylvanians who need health care or have and Medicaid and Medicare. And we engage in policy advocacy to increase access to quality health coverage and services for Pennsylvanians. I want to give you a brief agenda so that you know where we're going with this webinar. I'm going to very briefly review community health choices, just so that people make sure that you're in the right webinar and you will be able to understand whether this applies to you or the people you work with. I'm then going to talk about service reductions, terminations, and denials in community health choices, requesting a grievance, an appeal of a service denial, termination, or reduction, how to prepare for the grievance, and presenting the case at the grievance. We will then take questions, and any questions we can't get to, we will be able to see afterwards and reach out. So, because we're talking about Medicaid and healthcare, we are inundated with acronyms, and I try not to use too many, but I couldn't resist. So briefly, the acronyms you're going to see, this is more of a reference slide as you're going through. Our Community Health Choices, which is actually the program I'll discuss in a minute. There are 3 health plans in Community Health Choices. Those are the CHC MCOs. Those health plans are AmeriHealth Caritas, also known as Keystone First, depending on where in the state you are. There's PA Health and Wellness, and UPMC's Community Health Choices. Another acronym I'm going to be using is long-term services and supports. This includes a lot of the waiver services people have been receiving in the home and the community. It also includes nursing home care, personal assistance at home, modifications to make a home accessible, non-medical transportation, and other services that help people remain in or transition to the community. I'm also going to use the acronym PAS. That is Personal Assistance Services. These are services from an aide that help people in their home or when they're going into the community to perform daily activities and tasks, anything from meal preparation to transferring, bathing, assistance with shopping. There's a whole range. And finally, the other acronym I'll use is PCSP. This is the Person-Centered Service Plan. This was the subject of David's webinar in this series last week. And this is really the core document that specifies the CHC participants' goals, including their community living goals, their preferences, their need for services, and how those services will be received. So let me start with a brief overview just so we're all on the same page. Community Health Choices is a new Medicaid managed care program for certain people on Medicaid. It delivers and pays for Medicaid physical health services, and it also covers long-term services and supports for people who are eligible. Not everyone in CHC is going to get long-term services and supports. The people who are eligible for CHC are dual eligibles. That's a term of art, which means people who are on both Medicaid and Medicare, as long as they're over 21. And this is whether or not they need any kind of nursing home care or services in the home. It also includes others who are 21 and over who need the long-term services and supports. This is people who had been in the aging and physical disability waivers or in a nursing home. There are also certain people who are excluded from CHC, including people with intellectual disabilities and autism waivers, state-operated nursing facility and state veteran home residents, people who are eligible for the Office of Developmental Program Services, and anybody under 21, as well as people who are in the LIFE program, which is the Living Independently for the Elderly program, which is available in some parts of the state for people who are 55 and older. Now, Community Health Choices is not everywhere in Pennsylvania. It started in January 2018 in the Southwest, and that's the Zone 1 you see on the screen. It is coming to the Southeast, 5 counties in the Southeast of Pennsylvania in July 2000. Sorry, that's a typo. That should be January 2019. And I will update these slides before they get sent around. And Group 3 is going to be January 2020. So they're each a year apart. I think there had originally been a plan for 6 months apart, and this slide needs a little updating. So now that we're all on the same page briefly with what Community Health Choices is and who it's for, let's talk about service reductions, terminations, or denials. And the reason we're talking about this is because people's CHC plan, their managed care plan, make decisions about the amount of services people are going to get and whether or not they're getting the services and the scope of those services. So in the Southwest region, plans may begin reducing, terminating, or changing services beginning July 1st. So that was the beginning of this month. Prior to that, anybody who had been in a waiver who was moved into Community Health Choices was able to keep those long-term services and supports going without any change. So effective July 1st, that can change. Now, there can be no reductions or terminations of services unless the plan has completed a comprehensive needs assessment and a person-centered service plan. So a comprehensive needs assessment is really an assessment of the person's physical, behavioral, social, and environmental needs and desires. And then it's incorporated into this person-centered service plan, which looks at a person's goals and builds services around those goals. And if you want a review of those two things, I urge you to review David's webinar from last week. But the critical point here is, if somebody who had been getting services through a waiver was moved into Community Health Choices and is then getting a notice that one of those waiver services is changing, if they didn't have this comprehensive needs assessment and person-centered service plan, that change shouldn't be happening. That has to happen first. Now, when there is going to be a change, the plan has to send a written notice to participants at least 10 days before that change. That's not a very long time, so it's critical to open and read all the mail from the managed care plan right away. There are valuable rights, which we will be discussing, that could be lost if somebody misses some mail. If you don't understand what's in a notice, ask a service coordinator or call PHLP and we can talk to you about the notice. And it's also important to keep those notices and those letters and the envelopes they came in, because the envelopes have a postmark and that can kind of give you a sense of how quickly the plan actually sent the notice after it made a decision. So I'm going to talk about the 3 most common type of denial notices that people might receive. And this is going to include denials for initial requests for services. So somebody who may not have been receiving any services at all or is new to CHC may come in and want some waiver services if they're eligible and request them and receive a denial or a partial denial. The 3 types of denial notices that are commonly seen are a complete denial, a partial approval, which is really a partial denial, and approval of a different service than requested. So the first, I also want to note that there are templates for all of these notices that all the plans have to follow, and it's good to familiarize yourself with how they're laid out, because that way when you start seeing notices, you'll know where to look to get the critical information. And there are links that are going to be available with the 3 template notices I just mentioned combined, and there's a link at the bottom of the screen. So the complete denial notice reads denied completely. This means the plan is going to stop one or more service, or it's denying a request for a new service or item, or a request for an increase in services. So I'm going to give a couple examples. I'm going to warn you that a lot of my examples involve personal assistance services, primarily because those are widely used services, but also because we've seen a lot of notices around personal assistance services and a little less around the other services. So here's an example of a complete denial notice. Somebody was getting 20 hours of personal assistance, but the plan is going to stop that entirely. You also might have somebody who requests a vehicle modification, but the plan denies that request entirely. A vehicle modification is a modification to an automobile or a van to allow somebody with a disability to be able to use that van either as a passenger or as a driver. Now, I do want to note that some plans have used the complete denial notice when they're reducing services, so it can be a little confusing. The second common notice is a partial approval notice, which actually as I said, if you're partially approving something, you're also partially denying it, so it is a form of a denial. It will say approved other than as requested. And it means that the plan is intending to reduce one or more services or is only approving part of a request. So, for example, somebody might have been getting 49 personal assistance hours per week, but the plan is going to reduce it to 25. Or they're requesting 30 hours for the first time, but instead of providing 30 hours, the full request, the plan approves only 20 hours. The third notice that is seen commonly is an approval of a different service notice. This is also a denial because the service that's actually requested is not being approved, but a different one is. It reads denied as requested, but the following service or item is approved. This means the plan is intending to stop a service or item, but offer a different service in its place, or it might be denying a request for a new service or item, but offering a different one. So for example, somebody who is getting 25 hours of personal assistance might get a notice that's saying, instead of getting personal assistance anymore, we're going to approve you for adult daily living services instead. Or it might say, we're approving you only for 20 hours, but the rest of the hours are going to be adult daily living. It can vary a lot. These are just sort of general examples. So In addition to a notice telling you what's going to happen, it also needs to give a reason for the reduction, termination, or denial. And it can't just give any old reason. It has to be an adequate reason, a reason that is detailed enough for a person to understand why the services are changing. The language you see on this slide comes from one of the notice templates that you'll have access to, and it specifies that it has to give every reason for the denial, and it needs to provide references to any guidelines like medical necessity guidelines, any rules or protocols that the plan has on which the decision is based. And this notice has to be in language that's understandable. And finally, if the notice is a denial because there's not enough information from the person to make a decision, it should identify what additional information is needed so a decision can be made. So the prior slide was about adequate notice. Let's talk about what inadequate notice might look like. And the reason I'm bringing this up is because since the end of the period where people were able to keep their waiver services the same, that was called the continuity of care period in CHC, we have seen a number of notices changing services or denying services that just don't give a reason. They give a conclusion, but not a reason. And these are some examples of what we've seen, and these are inadequate if there's not more information provided to back it up. So we've seen just simple statements like, the service you requested is not medically necessary, or you are assessed as needing fewer hours of personal assistance, you are assessed as not needing this service. That's not enough. There needs to be something more that provides sufficient detail so that a person understands what they need to challenge or to understand whether the decision is even correct. So the Pennsylvania Health Law Project wants to hear about notices that leave you guessing as to the reason why your plan is reducing, terminating, or denying services. This is really important. The plans are being monitored by the state, and they have actually they're looking at all of the plan notices, and the plans are in what's called corrective action right now, which means all the notices are being looked at, and until the state says that notice is okay, they can't actually change the service. So we are very interested in seeing notices that you're not sure adequately explain the reason. And we may have a different view than the state on what an adequate notice is, but we are in agreement with the state on the two examples I gave. So we're very interested in seeing how these going forward as well as the plans are being monitored. So this slide has our 800 number, as well as an email and a fax number. If you need to, you of course should redact the notices, and we can also talk to you about them and maybe get some background information. Okay, so you got the notice, now what? It's time to request a grievance if you disagree with the decision. And let's face it, we're here on this webinar for situations in which we disagree. So the basics of a grievance I want to review briefly. A grievance is really a request to the plan that it change its decision to deny, reduce, terminate, or change a Medicaid service or item, or to not pay for it. It's a name for most of the appeals that are made to managed care plans. So in Pennsylvania, an appeal is usually called a grievance. Now, who can request a grievance it's not limited just to the participant. Of course, the participant can request one, but also a person who has been granted power of attorney by the participant may request one. Someone who has guardianship over someone in Community Health Choices may request a grievance, but also third parties, service providers, or other persons with written permission of the CHC participant. And that would, of course, include organizations with advocates like Pennsylvania Health Law Project. So we do still need written permission, but other people can make those requests for you. So here are just examples I want to point out of like the types of decisions that can be challenged at a grievance. The first set, the plan's decision to do something, those mirror the denial notices we discuss. A decision to reduce, suspend, or terminate an item, to deny it entirely, to deny a request for service but approve a different one. But you can also appeal decisions by service coordinators. So the type of decision you can appeal that a service coordinator makes is that person's decision not to include in the person-centered service plan a service or item that the participant desires, or to include it at a lesser amount than the person desires. So the contract that the plans have with the state, it's called the CHC agreement, says that a participant may appeal part or all of their service plan. Now, the service plans are supposed to be signed, so as a practical matter, somebody may still sign something and make a note, I disagree with these services and here's why, I want a grievance. We haven't seen these examples yet because CHC is pretty new, but I wanted to point that out because there could be a situation where somebody is seeking 80 hours of personal assistance and the service coordinator might say, well, based on my experience, you're just not going to get that. Let's just ask for 40. And if you disagree with that decision, you can say, even as they put in the request for 40, I still want the 80. Or if you ask for a vehicle modification and it's not put in or something else is put in instead, you can say, I disagree with that decision. Okay, so there are 3 ways to request a grievance. This is the practical slide. You contact the plan by phone, fax, or email. And the plan has to assist in filing a grievance if asked. So what this means is if you need help formulating the grievance or explaining what you're seeking, the plan should be putting it down in writing. Now, if you do a phone request, write down the name of the person at the plan you speak with and the date and time of the call. Most calls by plans are recorded, and so it's just a way of documenting that you actually made the call, and then often it can be researched if there's ever any dispute about whether or not the person actually filed the grievance by phone. I'm not saying we've seen this, but this is sort of a precautionary measure. And then after the call, if you can, send a letter to the managed care organization confirming the grievance request. And on the next slide, we'll talk about what to include in that letter. The other thing is if you are unable to write a follow-up, you can ask the plan to include any of the information I'm talking about on the next slide in your grievance request when you're talking to them over the phone, and then have them read it back to you so you can make sure that they're accurately writing down what it is you want to grieve and why. So there is a complaint grievance request form that is part of the template notices. So that should be included with the notice that you get. But on the off chance that it's lost, or if you're doing this over the phone, make sure you include the following information in your grievance. And you can also add, to the form and say, I want these other things in addition. So make clear that you want to file a grievance. Explain what you're appealing and why. So I'm appealing the denial of my request for home modifications. In terms of the why, if you're not sure exactly what you're going to say about why you need it, that's okay. You can still add that later when you're at the grievance. But if you know why you're disagreeing, you can put that down. Make it clear that if you got a notice that's going to change a service you were already getting, that you want the service to stay the same while you're waiting for the grievance decision. So if you were getting 90 hours of personal assistance services and the notice says it's being reduced to 50, you say, I want it to stay the same. And that way you'll continue to get the 90 until the plan makes a decision on your grievance. And actually, maybe even beyond if you appeal beyond that. For people who are requesting a new service or an increase, you don't get the service that you requested while you're waiting for a grievance. So in those cases, that wouldn't be relevant. You also want to include whether you want to do the grievance by conference call or in person. You should request all of the information used by the plan to make its decision. And this can be very helpful because it can shed light on what's behind the reasons that the plan gave. Or is there really enough information back there? Or maybe you'll be able to say, this wasn't justified because this is all you have is this one assessment of me, and I have a doctor who says I need more. That's just as an example. And also indicate whether someone else will represent you and who that person will be. Okay, so I want to talk briefly about the timelines for filing a grievance. And there are really two situations. So in one situation, if you want to keep your services the same, and in the other situation, if that's not an issue, you have a little more time. So to keep the services the same during the grievance, you need to file the grievance request prior to the effective date of the notice or within 10 days of the notice mail date, whichever is more beneficial. Each notice has an effective date, so you'll know what that is. And I'll give an example on the next slide of how this works. I do want to note, though, prior to the effective date of the notice is your right. It's under the federal regulations. But the denial notices don't mention this longer time. And often in health choices, which is what the precursor to community health choices is, the people would really get a notice 10 days before the effective date. So it would be really the same thing. The other thing I want to note is the date of a notice should be the same as the date it's mailed. So if you look at the postmark, it should be within 1 or 2 days. If you miss that deadline for some reason, or if you feel like you're not in a rush to file the grievance because you've requested a new service and maybe you're going on vacation and you don't want to have a grievance too soon, you have within 60 days of receiving the notice. Okay, so here's an example of how that alternative of if you want to keep the services the same during the grievance, you have to either file before the effective date of the notice or within 10 days of the notice mail date. So this is Anya. She's kind of an orange blob, but her name is Anya, and she gets a notice from her Community Health Choices plan saying her hours are going to be reduced from 63 to 40 hours per week on August 1st. The notice is dated July 15th. So 10 days from about July 15th would be July 25th. But she actually has more time than that because the services aren't going to be reduced till August 1st. So she really has until July 31st to request a grievance if she wants to keep her personal assistance service hours at 63 hours during the grievance process. And this might be an obvious tip, but request a grievance quickly. That's sort of the bottom line. I wouldn't worry too much about is it 10 days or the effective date. Just request it, almost immediately. You can always withdraw a request for a grievance if you decide you no longer want to appeal. But if those services are important to you, you really want to make sure you keep them while you're waiting for the appeal, the grievance. So after you request the grievance, you'll get a grievance acknowledgement letter that'll state why the grievance was filed and when the plan received it. And if it's not accurate, you should contact the managed care plan and clarify. So if it misstates your reasons for the grievance, clarify that. And of course, the services will continue if you requested them in a timely manner. So now that the grievance process is underway, you want to prepare for the grievance. And before I get into that, I want to just give an overview of what a person's rights are during the grievance process. So you have a right to submit additional documentation in support of your request for whatever service or item you're seeking. So it doesn't have to be limited to what was originally sent to the plan. You have a right to present your evidence and your arguments in person and in writing. You can participate in the grievance by phone, in person, or video conference. So grievance can be an actual event if you do it by phone, in person, or video conference. You have to let the plan know that you want to participate and how, because otherwise the plan's going to make a decision without your participation. And they can do that if you decide you don't want to appear. But we generally recommend that people appear, and when I say appear, I mean by phone, in person, or video conference. Now, if you go in person, the meetings are held at locations in each of the CHC zones. I have to say, whether that means in multiple locations or one location and how convenient that has to be is still, there isn't any guidance on that, so that's still being worked out. But we would be very interested in hearing from people, generally if you need assistance, but if you've scheduled an in-person grievance that's ridiculously far away for you to get to, or almost impossible to get to, or not even almost impossible, like you have to travel more than an hour, it would seem, that we want to hear about it. We're trying to get a sense of where these should be held and what we can talk to the state about in terms of advocating for convenient locations. The other thing is, when you're going to have this grievance event, you get 15 days advance notice of when it's going to be, so you have some time to prepare. It's not a lot of time, and preparation is essential. You vastly improve your chances of succeeding at the grievance if you're well prepared. You want to think about and understand what you want to show at the grievance, and figure out what information best shows that the services or items that are at issue are needed so you can meet your needs or goals as they're listed in your person-centered service plan. The reason we had that hour-long webinar last week on person-centered service planning is because what you put in that person-centered service plan as your goals is so critical. The services should be supporting that goal. So if you can show a service you requested supports that goal, you're on your way to showing that you should be getting that service. So at the grievance, you're going to have to prove that you need the service or item. So you want to be able to talk about why you need it and how it meets the CHC medical necessity definition. And I'm going to talk about this on the next few slides, so hang in there. I want to just point out, though, that just because you need to meet this medical necessity definition doesn't mean that the service or item has to be medical. The need for job search assistance doesn't seem particularly medical, but guess what? The definition of medical necessity actually encompasses people being able to access services that help them live and work in the community. So don't be intimidated by the word medical. It's not, it's a very generous definition of medical necessity that the program uses. The other thing to bring up at the grievance is any issues with the process by which the plan told you about its decision to deny or reduce or change a service. For example, as we discussed before, that there's not detailed reasons for the decision, or that comprehensive needs assessment that was discussed last week hasn't been completed, or that the person-centered service plan wasn't completed, or not provided to you, or not signed by you. So if you didn't get a copy of the person-centered service plan, that's a problem, because it is a requirement that that be made available to the participant and that they be able to sign it. Okay, so let's talk briefly about medical necessity, because this is what you're proving at the grievance. So a Medicaid service is medically necessary if it does one or more of the following. This is a 4-part definition, but you only need to meet one of these definitions for something to be medically necessary. And the first three parts of this are what you kind of think about when you think of like something being needed because of a medical need. When something will or is expected to prevent the onset of an illness or condition or disability. Or number two, something will or is reasonably expected to reduce or ameliorate the physical, mental, or developmental effects of an illness, injury, disability, condition. Or the service, the item you're requesting will assist you in achieving or maintaining maximum functional capacity and performing your activities and tasks that you do on a daily basis. The fourth definition in the medical necessity definition is really what a lot of the long-term services and supports in the community will need to be connected to, and it makes the most sense for them. So keep an eye on this definition, because this is where services like pest eradication, job search assistance, even personal assistance can come into play. So if something if a service or item will provide you the opportunity to have access to the benefits of community living, achieve person-centered goals, and live and work in the setting of your choice, then it's medically necessary. So what you're doing at the grievance is you want to show, how does this service or item that I was denied, how is it needed so I can achieve one of my goals that I put into my person-centered service plan? Or how is this service needed so that I can work or live where I want to be, in my home or in the community? This is why it's so important to make sure the goals that you have for living in the community and your preferences are in the person-centered service plan. Because you're really going to want to connect, when, at least, even if it's not done in the person-centered service plan, when you go into that grievance, you want to connect, I need this service because it's going to help me achieve my goal of living in the community. It's going to achieve my goal of being able to go to religious services, things like that. You know, maybe you need non-medical transportation, you have a goal of going to religious services. I'm going to go back to the slide once again. This is what the most important thing you're going to need to know probably from this webinar, other than the time limits. Just think about the person-centered service plan and how you can make sure that your goals are there, so that when you ask for services, it's clear that you need them to support your goals. Okay, and I'll move on now. All right, the next thing you're going to want to do is gather evidence. You're going to gather evidence from the plan, and you're going to gather your own evidence. You have a right to review all relevant documentation pertaining to the subject of the grievance. So that means you should specifically request all of the relevant documentation. This is anything that the plan used to make its decision. So you also want to request that. The documents, the policies, the protocols that they relied on in deciding to deny a service or reduce or terminate it. You're also going to want to ask for the comprehensive needs assessment that was done and your person-centered service plan, because you want to be able to look and see what they put in there to make sure that it accurately shows what your needs and abilities and desires are. And I also mentioned that you're going to want to ask for, this is a term of art, tasking tools. So if personal assistance services is an issue, some plans, at least one plan we know, uses a tool that kind of decides how long it should take a person to perform certain tasks. And we don't know a lot about this tool because CHC just started, but it's kind of like you can plug in, it seems to be that information about the person's needs and abilities are plugged in, and out comes a number about the number of hours they need of personal assistance. That's probably an oversimplification, but because that's used in making the determination about how many hours are being authorized, you're going to want to see that, because it may not reflect how long it takes you to do certain things. Like it may say bathing takes 10 minutes. Well, for you, with your assistance of your aide, bathing may take 20 minutes. You know, it may depend on your medical needs, the configuration of your bathroom. There's a lot that goes into that. So you're also going to want to gather your own evidence. That includes evidence of medical conditions, your limitations, restrictions in performing daily living activities. You're going to want to see if you can bring in the service plan prior to community health choices, the one that you had under the waiver. That might show what your needs were then, and if they haven't changed, that's something that you're going to want to show at the hearing, at the grievance, excuse me, to show the plan, like, look, you know, you said I don't need this service anymore, but nothing's changed about my medical condition, and I needed it then, and it was documented, so what's changed? This is going to be more relevant further on, but you'll want prior person-centered service plans. So as CHC becomes more of the norm and is done with this transition process, people will have multiple person-centered service plans that they'll have had. So if a new one changes the services that the person is receiving, the old one may tell a story about what things were like for you, let's say in June 2018, and if in December 2018 you're doing the same, but the services that are authorizing are less, that's something you want to bring to the attention of the plan. You also may want to use medical records, doctor and provider letters that support the medical necessity of the service that you're requesting. So, see if you can have a doctor or provider write a letter that really ties in the service to one of the medical necessity criteria. And sometimes even vendor records can be helpful, so provider records. So for example, maybe there's an aide who's working with somebody in their home, and the aide has complained to the vendor that this person's needs are beyond those that are authorized. I'm doing so much more for this person that's in the plan, and there's not enough time in the day to get it done. So that's that. Now I want to just pause for a second and say, we've talked a little bit about personal assistance services and the tasking tools. We are planning to do a follow-up webinar, it hasn't been scheduled yet, focusing on different community long-term services and supports that people may be seeking in community health choices, and what the process of getting those services is and what to do when they're denied or reduced or changed. And personal assistance services is going to be the subject of one of those presentations. So hang on. It's a service that's very widely used, and we realize that people are going to want to know more about how to really get into preparing for a grievance on that. It's beyond the scope of this webinar, but I want to make sure you know that we do have plans to cover it. Okay, so then you're going to want to prepare for the grievance by identifying who your witnesses will be. These are the people who are going to speak to your needs and the services and your goals and what you need to support those goals, and why whatever's at issue, whatever the denied service or item was, can help you reach your goals is necessary for you. So the people to consider are the participant, any formal or informal caregivers, including aides, family, friends, even neighbors or building superintendents. Sometimes I've had clients in the past who've called upon their superintendent to help them out when an aide hasn't been available in times where they haven't had an aide. And that superintendent might be willing to talk about, like, I've had to help, Ms. Johnson on several occasions because of, this is happening and she needs more services. The other people who you can have as witnesses are doctors and other providers. Okay, and so back on I'm just going to quickly mention on the personal assistance services. As I mentioned, we're going to do another webinar, but remember I said that the plans are tracking they're using these tasking tools, or maybe using a tasking tool to decide how many hours of services a person needs for different tasks. You and your aide or informal caregivers want to track how long it actually takes. And this is on good days or bad days. So I'm mentioning this like a preview of the upcoming webinar. You want to track it, put it in writing, include the time it's needed for queuing to do tasks and the time an aide provides direct assistance to someone. And this is important because it demonstrates the time it actually takes an aide to complete tasks with you. And it counters the plan's assumptions about how long it thinks a task or an activity generally should take. Now you've gathered your evidence and the grievance date is coming. Now remember, PHLP can assist you. These are, I've given you probably just more information than you ever wanted to know. This is an overview. I'm just reminding you before we get into this. If you need assistance, please contact us. We just want to make sure that people understand what to expect from the process and what they can do while they're, deciding whether they want to appeal or reach out. So the procedures of the grievance is that there's a grievance committee, and this is 3 or more people, and they're the ones who are going to decide the grievance. If you're doing an in-person grievance, one of those people has to be in person and the rest will be by video conference. The grievance committee consists of people who are not involved in the original decision, the original denial, and they can't be supervised by someone who is also involved in that decision. And also some of them will not, at least a third can't be employed by the plan. And a licensed physician who's in a specialty that typically manages or consults on the service or item at issue also needs to be on the grievance committee. So it's a minimum of 3 people. And, remember this is an actual event. So the proceedings are recorded or transcribed. And the participant or whoever they've selected to represent them presents their case. Now, there are, in case there are any lawyers on the phone, there are no rules of evidence. You just present your arguments and your evidence. And there may be someone from there will be someone from the plan side also presenting why they denied a service. And I want to just warn you that there's no right to question that person. There may be some back and forth, but the grievance committee, could shut down if you start to ask the person presenting for the plan, why did you do this? That's not true. What you found. The committee might shut that down and say, like, we're just gathering information.
Amy, there is something I'd like to add regarding these procedures. The plans will often set aside a certain amount of time for each grievance. And we've had grievances where the amount set aside was as short as 15 minutes and others that went for an hour. So it's important that you be very concise and to the point because you may run out of time. But also for a grievance where they said, well, you've only got 15 minutes, you really should push back on the plan if that is an inadequate amount of time to present the information and to present your witnesses.
Thanks, David. So let's talk about how you present that evidence and those witnesses. So you can do this in writing and verbally. And as David mentioned, you have witnesses, yourself, the participant, and maybe others to talk at the grievance meeting. You want to sit down and think about in advance, how do you want to present the information and whether you want someone else, it even could be an aide or an informal caregiver, to be on the phone or in person to help you present the information you gathered. And it can also be helpful to send written information to the plan before the grievance. And the reason for this is that the grievance committee does have the ability to review your information before the meeting. And if they get additional information, sometimes the plan will reverse its decision and decide to actually authorize the services at issue. And then you don't have to go through this actual grievance meeting. So you really want to, if you have a limited amount of time, as David said, push back and make sure you can get an adequate amount of time to present your evidence, but you're going to want to front load the most important pieces. And you want to emphasize why the services that are being reduced, how the services that are being changed or reduced or denied meet the medical necessity criteria. And I've referenced, I think these slide numbers are off because I made a last minute change to the slide, but when you actually get the webinar, it will be corrected. So the services don't have to be medical to meet the medical necessity criteria. Remember that, and then look at the criteria and present your case for the services or item in the context of the definitions. You want to provide copies to the grievance committee of all the evidence and talk about why it's important and how it shows you need a service. Have your witnesses speak to your needs and how these needs connect to your goals and desires in your person-centered service plan. And then you can also describe any defects in the process, anything that went wrong during the grievance process, like the notice was not adequate, you didn't get your needs assessment, or the plan was incomplete. The committee has to make a decision this is from the agreement, expeditiously as the participant's health condition requires. This means no more than 30 days from the grievance request. It could add 14 days if the participant wants the extension. And if somebody requests an expedited grievance, it has to happen no later than 3 days. An expedited grievance happens when something that the service or item at issue is really urgently needed. And if a provider certifies or the plan determines that the participant's life, physical or mental health, or their ability to attain, maintain, or regain maximum function would be placed in jeopardy, if you had to wait the full 30 days and follow the normal course, then you can get an expedited grievance. Now, this slide is, you don't want to lose your grievance, but you can't necessarily control that. So if you lose your grievance, that is not the end of the story. There are two options for further appeals right at that moment. One is a state fair hearing, and you could also do an external review. And the good thing is, if the services were continuing while the grievance was pending, you can continue to get them while the fair hearing or external review is being determined, as long as you appeal within 10 days of the date of the grievance decision mailing. So if you don't miss that deadline, the services will be reduced or stopped. So again, this is another one of those moments where you really need to keep an eye on the mail. But there is hope beyond the grievance, the fair hearing process, and external review. And we are considering doing future webinars on fair hearings, but as far as and external review, but I'm not sure that there have even been any fair hearings or external reviews on CHC as of yet, because it's such a new program. So I think we can take some time for questions, if there are any, and if we run out of time, we can answer them over email.
Okay, so first question is, given the short time to respond to mailings, is there any consideration for when a client is in the hospital or rehab for a while? Often people have no one to check their mail when they are not at home.
David, can you take this one based on your experience with the other already in Pennsylvania?
Right. So there is a provision in the state regulations for good cause, as it's called, for a late filing. We have, it's not specified in Community Health Choices Agreement, but we have been told by the Office of Long-Term Living that the plans are being very flexible about this 10-day time limit. So I would suggest that if the individual comes out of the hospital to find one of these notices and appeals, that they explain to the plan when they call up to file their appeal that they had been in the hospital or been unable to get a hold of their mail. And if the MCO still refuses to reinstate their services, they should give us a call.
Okay, and someone else had a similar question that's slightly different. If you have rural service mail delivery, that means you only have access to your mail periodically. And can you request a reasonable accommodation for a longer period?
Well, actually, we don't have an answer to that one quite honestly. And I think that's something, again, we'd want to raise with the managed care organization and with the Office of Long-Term Living. I will say that the 10 days actually runs from the date of the postmark, but if in fact it has been mailed, but it takes 3 to 5 or more days to actually reach you, that does present a problem. And that's something I think we need to take note of, and we would really like to hear any examples of that happening, because quite honestly, we haven't run into that before.
When the participant decides they want to file a grievance, do the service coordinators become involved and assist with this, or is it completely the responsibility of the participant and their family?
So that's going to really depend on the service coordinator. And we have also heard from providers who will get involved and sort of assist. Just keep in mind, the plan does have to assist a person in actually filing the grievance if they make it clear they want to. And the service coordinator, I believe, also has that responsibility. But the extent of their involvement beyond assisting, whether they're going to advocate for the participants or not, is really going to depend on the circumstances and the individual service coordinator. Under Community Health Choices, service coordinators are really part of the administrative arm of the Community Health Choices plans. So they're not considered providers in this context. They're making decisions for the plans. Now, it's not always the decision that the plan finally comes up with, but again, it's really going to depend on the service coordinator and the circumstances.
Do in-person grievances need to be near you? If so, does the MCO provide transportation?
There's no requirement that the plan provide transportation. So I'm not sure, they don't have, I know that they don't have to reimburse you, although they are supposed to help assist you with the process. So that's kind of a good question. Do you have anything on that, David, on the transportation?
They don't, in regular health choices, they do not provide transportation, nor do they reimburse for transportation if you choose to do the grievance in person. And so that is a consideration.
In terms of where the grievance will be held, the Community Health Choices Agreement notes that there has to be a location in each of the zones. But if you remember from the map that I put up earlier, there are 3 zones, and particularly this the first zone, the Southwest, is quite large, and the third zone, which is sort of everywhere but the Southwest and Southeast, is quite large. So there's actually no guidance. This is something that needs clarification, and it's why I suggested we want to hear from people if they find that their grievances are being scheduled at a location that's completely inconvenient to them. It has to be an accessible location, meaning accessible to people with disabilities. But in terms of where within each zone, that has not been answered yet.
The other thing to keep in mind in terms of the in-person grievance, the plans are not required to have all 3 grievance committee members physically present at the location. So you may walk into what you think is an in-person grievance with just 1 member of the committee. The other 2 may be by video conference or by phone. So the in-person grievance is not always as useful as you think, because in many cases you are not face-to-face with all 3 members of the grievance committee.
Is there a way to file a grievance that you never got a person-centered service plan?
I think that might fall into, David, would that be considered a complaint?
Yes.
Yeah,
yes.
That would be a complaint, which is a similar process to a grievance, but if it falls under the same category. And if you call the plan and make that complaint, they should be able to categorize it properly as a complaint or a grievance. Did you want to add to that, David?
Yeah, I guess what's tricky about this other kind of an appeal, the one that Amy called the complaint, that is in fact a specific appeal which is established and recognized under state law. But if you use the term saying, I want to file a complaint, unfortunately, sometimes the member service people don't understand that that actually means a formal appeal where the rights that we talked about under the grievance process also apply. So it may be better in that context to just use the generic term appeal. I want to appeal the fact that I have not received my person-centered service plan, rather than try and say I want to file a complaint, because that may get misconstrued and not acted on as required under the CHC agreement and the regulations.
Okay. Do you know the maximum number of hours that could be approved? Also, can care be provided overnight?
So this is a question about personal assistance services, and there is no max number of hours. But so it's going to be really dependent on what the person's needs are and probably how the assessments are conducted, which is why it's so important that those assessments and the person-centered service plan be accurate. In terms of overnight coverage, that is available. I don't know how widely it's going to be available, but it is available for up to 8 hours a night, and it has to be with awake staff. So it's not a kind of service where somebody would be sleeping there and providing services. The aide has to be awake the whole time. And these are the types of things that we're going to look into discussing at our personal assistance services webinar.
How long will the grievance process take? Currently, a consumer filed an appeal for a reduction of hours about a year ago, and we still have not had a hearing.
Oof.
Well, so for starters, it's supposed to take 30 days. in Community Health Choices, but if that was an appeal that was filed over a year ago, it wouldn't have been Community Health Choices. It was probably a waiver. And David, can you speak to the waiver limits?
Sure. If it was an appeal from a waiver prior to Community Health Choices, that would not be a grievance. We didn't have grievances under the previous waivers, the aging waiver, independence, ComCare, OBRA, those, or attendant care, that those appeals went to the state for what we call a fair hearing. The time limit is 90 days. So that's well past.
Okay. Why is it that CHC MCOs get 15 days to respond while the person who is filing the grievance gets only 10 days?
So the 10 day, it can be more than 10 days, but 10 days is the notice that the plan sends has to give at least 10 days notice. And in fact, we have seen people getting longer notice, although that may change now that the period of time where people were able to keep their services unchanged has ended. But it was a decision. The 10 days is in federal regulations as the minimum, and there was no decision to extend that. And these are sort of what was come up with by the state and the plans and the agreements. I don't think there's anything more than that. And the 15 days you're talking about, the 15 days is how much advance notice of the grievance time. I'm not sure what other 15 days it would be.
Okay. Someone asked, what recourse does a consumer have if the appeal hasn't been heard in the 90 days David just mentioned?
Well, okay, so in the context of the 90 days applies to state fair hearings. And what the regulations say for state fair hearings and it's not just that the appeal hasn't been heard, but actually has to be heard and decided within the 90 days, that if it's going past the 90 days and you don't have a decision from a state fair hearing, the person is entitled to request what's called interim assistance, which is to say whatever it was I was asking for in my appeal, I now get that until the appeal is finally decided. Now there's some exceptions, like durable medical equipment would not fall into that, but then really that's a situation where you want to contact the Health Law Project so that we can contact hearings and appeals about these cases so they can get them resolved. On the grievance side, as Amy said, this shouldn't go beyond 30 days. And again, if has gone beyond 30 days, we want to hear about that.
Okay. Someone asked, deaf people who are depending on CHC MCOs are often unaware or don't understand the services that are provided in Pennsylvania. How can you resolve this?
Wow. So the responsibility is on the service coordinator to provide that information. The agreement does specify that communications from the plan to the individual must be in a format that is accessible to the individual. So that for a deaf individual, that might well be written material as opposed to something verbal. And for an individual who's visually impaired, it would mean that whatever format that individual uses, whether it is an audio tape or Braille or some other format, that is what has to be provided. But it's an issue that remains to be worked on, and we're most interested in hearing from folks by whatever format they use about issues they've had in getting information from the plans due to the nature of their disability.
Okay, someone asked, if there is no accessible transit method from me to the grievance, does it truly meet the standard of accessibility to people with disabilities?
So, I mean, that's actually a really good point. There is a requirement that so I mentioned earlier that the plans are required to assist people in filing the grievances. They're also required to assist people in being able to prepare for the grievance. And while the agreement doesn't specify providing accessible transportation, this is sort of getting into the sphere of ADA, Americans with Disabilities Act argument. There may be arguments that if there is no way for someone to have an in-person grievance because of the unavailability of accessible routes, that an accommodation may need to happen to make that happen. Again, as I said earlier, we are interested in this issue of where these grievances are located, and there have been so few so far that we really haven't had a lot of experience with where they're going to be located. So far it's just the Southwest where CHC exists, and I believe we've had a couple in person, but we've also been representing people. So this is why we want to hear if your grievance is scheduled at a location that is far away or not accessible by public transportation, accessible transportation, then that's something we should be made aware of so that we can do advocacy with the state.
Okay, and I think this is the last question for right now. Are there any circumstances where a participant would appeal because of lack of choice of providers?
Well, I'll answer that. I mean, yes, we certainly have. We have seen that in regular health choices. Now, what's tricky in terms of choice of providers, the requirements on choice, they're not really particularly useful in the context of many home and community-based services, because they often say, well, a choice of two, but that's not necessarily realistic. But you certainly do have the right to file an appeal. Now, it would not be a grievance. It'd be this appeal we called a complaint that we talked about previously. But yes, you must be given that choice. Now, let me say that there are some situations where the plans, with approval from the state, have contracted with what they call brokers for some of the specialized services, and most notably for non-medical transportation. So in that context, depending on what plan you are, you would be using a particular company who would be managing the non-medical transportation, although there typically will be a number of different providers in their network, but you would have to use that particular broker for arranging for your non-medical transportation.
Okay, and that seems to be all the questions for right now.
Well, I want to just briefly say thank you very much for attending the webinar. If you do find that you have different questions, you can email the staff at phlp.org email, and it can be forwarded to me or David so we can look at the questions. And I believe there's also an ability to do it through the webinar. And thank you very much. Look out for future webinars on accessing personal assistance services and appealing denials and reductions of personal assistance services, as well as other webinars on community health choices, including around the rollout in the Southeast. We're going to move backwards to the basics on the Southeast webinars.